Hello everyone, welcome back to our legal channel. Today we focus on crucial development in personal insolvency law under IBC. The NCLAT has clarified that bankrupt individual can seek discharge after 1 year, even if the bankruptcy trustee failed to act. So this is strengthening debtor's right and setting a new benchmark for professional accountability. Let's understand exactly what happened, and we'll see the legal basis and why this is a big deal. So I'll explain the background of the issue. This case revolves around the long pending personal insolvency resolution. This is a personal insolvency process initiated under Insolvency and Bankruptcy Code 2016 against the debtor, now bankrupt, wherein Union Bank of India was the key financial creditor. Here is the timeline. Issue is bankruptcy commencement date over 2 years ago. Bankruptcy trustee was appointed. E-action for the assets. E-action of the assets was conducted, but later nullified due to procedural issues, procedural lapses. Then Union Bank relinquished its security interest in the bankrupt's property. Then, despite all this, the trustee did not file an application for discharge, which is under section 138 of the IBC, is a mandatory step after 1 year from bankruptcy commencement. So we'll see what section 138 says. Under section 138, subsection 1A of the IBC, the bankruptcy trustee is required to file an application for discharge on the expiry of 1 year from the bankruptcy commencement date. Timeline is not an optional, it is a mandatory, it is a time bound. But in this case, the trustee failed to act. And even after acknowledging the obligation in COC meetings, did not proceed. This is a basic issue. So the NCLT order that sparked the appeal frustrated the delay. The bankrupt filed an application directly before the NCLT, urging the court to consider the discharge in view of the trustee's inaction. But NCLT dismissed the plea, calling it disruptive and premature. The bankrupt then approached the Honorable NCLAT, appeal, citing earlier liberty granted by the appellate tribunal itself and finding out that more than 2 years had elapsed without progress. Then NCLAT's key observations was NCLT and NCLAT strongly disagreed with NCLT's reasoning. It held that section 138 imposes a clear duty on the bankruptcy trustee. So the bankrupt has a right to approach the court if the trustee fails to act within 1 year, even the statutory time frame. Delay cannot be justified by citing creditor indecision or pending asset sales. So the tribunal also referred to historical insolvency framework both in India and globally, where timely discharge is considered as a right of the debtor. They need to uphold the legislative intent of a time-bound resolution. So the final directions of the NCLAT, the bankruptcy trustee must file a discharge application within 15 days. The NCLT must adjudicate the application within 3 months. This ensures that the insolvency professional remains accountable. Debtors are not penalized for the procedural inertia. IBC's promise of timely resolution is honored. This is finally the directions of NCLAT. So bankruptcy trustee must file the discharge application within 15 days. So this is what the right of the debtor. We have 2 channels, RR Corporates and RR Legal Talks. Please do subscribe so that you will not miss any of our latest videos. Thank you.